Hello and welcome to another episode of Immigration Insight. I'm your host, Harry, and today we'll be exploring how U.S. citizens can file for their parents to come to the U.S. as permanent residents. We'll also dive into the differences between consular processing and adjustment of status, plus a critical point, the 90-day rule. Joining me, as always, is our resident immigration expert, Shah Peerally. We'll also hear from one of our callers with a question about her parents' immigration case. Let's get started. As a U.S. citizen, once you turn 21, you can petition for your parents to become lawful permanent residents of the U.S. It's a big step that involves filing Form 1130 to establish your relationship and begin the process. Since your parents are considered immediate relatives, there's no visa cap or waiting list, which makes the process faster compared to other family members. But how your parents go through the process depends on where they are when the petition is filed. That's where we get into the two main pathways: consular processing and adjustment of status. Shah, can you explain the difference between these two processes?
Sure, Harry. So, consular processing is for parents who are living outside the US at the time of filing. Once the I-130 is approved, they'll go through the US consulate in their home country. After completing some paperwork and a visa interview, they'll be given an immigrant visa, allowing them to enter the US as lawful permanent residents. On the other hand, adjustment of status is for parents who are already in the US and want to change their visa status to permanent residency without leaving the country. Along with Form 1130, you'll file Form Y-485, and your parents can stay in the US while that's being processed. Plus, they can apply for work authorization and travel permits during this time. Both processes lead to the same result, but one requires your parents to be outside the US, and the other can be done from within.
That's a great breakdown, Shah. Now, I know some of our listeners may have parents in the U.S. on tourist visas, which brings up an important point: the 90-day rule.
Absolutely. The 90-day rule is crucial. If your parents entered the US on a tourist visa, they are expected to leave after a short stay. If they apply for adjustment of status within 90 days of entering, immigration authorities might think they had the intent to immigrate all along, which could be seen as visa fraud. The safest route is to wait until after the 90-day mark to file.
Thanks for calling in, Maria, and thanks again to Shah for breaking down the process and helping us understand the nuances of the 90-day rule. Whether you're going through consular processing or adjustment of status, the key is staying informed and making sure your paperwork is in order. If you need further assistance or have specific questions, feel free to reach out to Shah Peerally Law Group for personalized help.
You can contact them by visiting their website at www.peerallylaw.com, by phone at 510-742-5887, or via WhatsApp at +1 279 218 7093. Visit www.peerallylaw.com. They're here to help guide you through your immigration journey.
That's all for today's episode of Immigration Insight. If you enjoyed this discussion, be sure to subscribe to our podcast and leave us a review. We'll be back soon with more insights to help guide you through the immigration process. Until next time, stay informed, stay empowered.